You have a question. How do you create a will? More importantly, where do you start in creating a will? Well, let's take a look at a little trade secret that the legal industry uses, particularly a lot of your local law firms use, and the assistants in creating a will for you. They use a will questionnaire or a will check sheet to help them create the will for you. You're in luck. You can go to your local library and ask for the Law Check Will Questionnaire or Will Check Sheet, and you can actually download it and start the process right away. So go to your local library and look for that Will Questionnaire, Will Preparation document from the Law Check forms. Hello, my name is Vincent Punt, Vice President of Laws Online, the national database of legal professionals. In this video, we're going to look at the quick and easy process to fill out a will questionnaire. Now, this isn't legal advice. We always recommend that you get local. That means you get to your local attorney and you ask them to help you in your will creation process. This is one of the most economical things you can do with your local attorney. It's going to be something in the neighborhood of roughly $500 to maybe $1,000, depending on the size of your estate. But it is one of the more economical items you can do with your local attorney. The reason we recommend your local attorney in creating a will is you want it done correctly. Those wills that are not done correctly have a tendency to cause problems. One of the problems is you don't have a will when you pass on. There is no control of where your property is distributed. Your property may be distributed to a long-lost relative or a bum family member who you had no intention of giving any property to, but the state uses an inheritance based on your relations, not your friends. The other problem with not creating a will or not having it done properly is there's no control over who's going to administer your estate. When you pass, the state that you live in, the government, will decide who's going to be in charge of distributing your property. Not you, because you decided not to do a will. That's why it's so important to not only create a will, but have a local legal professional help you with the creation of that will. So after you've had a chance to download that will questionnaire from your local library, we're going to go through that document relatively quickly. That Law Check form is about a one-page document, and it's going to help you get on the path of beginning the will process. It's relatively simple and straightforward. Let's open it up and take a look. The very first thing is the testator contact information. The testator is you, the author of the will. It's a fancy way of saying who's the author of this will, the testator. And in this case, we're going to put the individual, John Doe, their address, 331st Street, Southeast, Cedar Rapids, Iowa. I'm using a general address. You'd put your address in there. Now, the phone and email are for contact information for the law firm that's creating the will, or for the legal professional creating the will is going to need this information so they can get in contact with you if they have questions. So we're going to put a phone number in there, 515-631-5474, and we're going to put our email in there, johndoe@lawcheck.net. Next, the question on the will questionnaire is, are you married or not? This is important because if you're married, your spouse will most likely be the primary beneficiary if you pass before your spouse. So you want to go ahead and either mark yes or no. And if you are married, put yes. And in this case, we're going to put Jane Doe. After your spouse section, there is a part for children. If you have children, mark yes and put their names under beneficiaries. When you're creating your will with your legal professional, this is a great time to ask the following questions. First of all, have you created a past will or made a codicil to that will? If you've already created a will, you want to have this will replace it. You cannot have two wills exist at the same time. If you can't remember, say no and say, I don't believe I do have a previous will, because in that case, they're going to remove any reference to that will and you're going to reject any wills when you create the new one. So when you create a new will, it will be the primary will. All other wills before that will be extinguished. If you do know, if you have a will, go ahead and put that in and the year it was created. Next, you have the option to do a living will. And we recommend that you do the living will at the same time you're doing a will. If that's your choice, if you want to do that, it's more cost effective to do these things all together. So not only are you doing a will, you're doing a living will, which is usually a separate document. It's not included in the same one. Next, you want to probably create a power of attorney. Again, this is a third document. It's not going to be necessarily part of the primary will. And so you want to probably go through that process of doing it. Now is a good time to do the power of attorney because this is something you can use in case you're incapacitated or a severe illness happens. Finally, you can ask if you need a trust. If you wish to have a trust, this is a great time to set that up. You can be more cost effective if you're going to actually work with your local attorney to get that trust created. In this case, we're not going to, so we'll mark no. I would ask if you have pets, and if you do have pets, you could look into a pet trust. And that's something that, in this case, we're going to say no, but in some cases, individuals may have pets, and you would want to probably work with your local attorney on some form of protection for your pets. A trust is one option. You've completed the first part, the testator. The second part, the executor. Who's the executor? The executor is the person who's going to administer your estate when you pass on. This is the party who's going to decide the distribution of property. That's what the executor is. And in this case, we're going to want to name executors because we want to have control of our estate. So you would probably, if you're married, put the very first executor is going to be your spouse. Spouse is in there, and then their address. You can also put in a other third-party person who's not related or not your spouse. And in that case, we're going to do that. We're going to add an individual here as an alternative, but we're going to put in Bob Blank, address 4211 Glass Road, Northeast. You may want to have a third executor, and there's an attachment to this questionnaire that you can add a third executor. It's always good to have a 1, a 2, a 3 options for the executor. Don't just appoint one person. Think this out. That's why you use the will questionnaire. Put that question in there saying, who do I want first as my executor, second as my executor, and third as the executor. Always have a backup plan in case something happens to the executor you have named in your will. So it's recommended at least 2 to 3 executors named. Next, beneficiaries. Beneficiaries are the people who are going to receive the properties that you're distributing through your will. That's basically what they are. Beneficiaries don't necessarily have to be related, but they are the parties who are benefiting from your will, who are receiving property from the will. Here we're going to name the beneficiaries of this will. We have a kid 1 who's going to be a beneficiary. We're going to put the address. And then I have a friend, Frank, who's going to be another beneficiary. You may have more beneficiaries, and you can use the attachment here. Again, these are the people you're naming who will receive property. You don't have to decide what property they're getting. You just have to name the beneficiaries and get the name spelled correctly so your local legal counsel has that information when they're creating your will. Next, it's important in your will to identify real property. Most states it's important because this is where the will comes in to play, is real property is a major item that has to be distributed in a more delicate manner. Real property is your homes, real estate, land, something that's non-movable in that case. And real property has a delicate way of being handled. Therefore, putting your real property that you have ownership in or stake in into your will is important. And that's what this section is here under 4. And we're going to put in the property they live at, 331st Street, Southeast, Cedar Rapids, Iowa, 52403. Next, vehicles owned. Now, this isn't real property, but these could be important to determining for your beneficiaries. So we are going to name the vehicles that are owned. Here there's 2 spaces. If you have additional vehicles, you can add that to the back. Same thing with the property. If you have additional property, you can add that to the attachment. But here we're going to put in the first car we have, which is a 2017 Chevy Equinox. And then the second one is a 1990 Nissan Pathfinder because it's a collectible. It's a collector series. So we're going to add that in there because we want to make sure that that's distributed to the party members. 6, stocks, bonds, insurance policies, retirement programs. This is another thing you need to think about. What insurance policies, stocks, bonds do you have as ownership? And you want to start listing those items to get those organized. Again, you want to name that information here, and then you can give notes on how you want the beneficiaries to receive that. That's something that you can carry with you when you talk with your legal professional. Here you just want to identify, again, identifying that property, the stocks, bonds, insurance policies, retirement programs. This way it makes it easier for your will to move quickly if you have that already identified when you talk to your legal professional. Finally, you're going to take a look at collectibles. These are personal properties that might be a coin collection, stamp collection. Maybe you have a certain book collection that is got some value to it because it's a rarity. Here I'm going to put a rare book of John Carter, Princess of Mars, the 1920 original book, hardcover or paperback, that we're putting in here that's going to be used as a collectible. And who receives that can be decided later. We just need to identify that. And that's what really this will preparation questionnaire is to identify what assets you have in your estate so that they can be easily distributed. Remember, if you don't identify the property, it makes it harder for a future executor to know what property to provide. So that's what this questionnaire does, is really helps you in identifying. That's primarily it. If you look at your attachments, there's additional notes on how you wish to have this property distributed. But you can sit down and create your first will questionnaire in a few minutes and have a document ready to go when you talk to your legal professional. You've just answered the question, where do you start in creating a will? You use a will questionnaire or a will check sheet. And you can get those at the local library under the law check forms under will questionnaire. We hope that this video has helped answer that question. Where do I start with the will? Start right here with this document. This isn't an actual will, it's just a questionnaire to get you started. But it'll help you on the path and make the will transition a much smoother and easier one. Again, we recommend you get local, find that local attorney, and take this questionnaire to help get that process started. Thank you very much, and thank you for watching this video provided by Laws Online and Law Check.